spoke about the Dharmashastras and their continuity and when they were sort of compiled or written. I mean, we came to know that Indian civilization was as progressive as 5,000 years ago. What the rules are more or less the same even today as well, because they had that vision of stating those laws even then, right?
See, it all springs from the fact that man never changes,
Mm.
and man's interaction with other men or with the society will not change.
Yeah.
And the emotions will not change.
Mm.
Your desire to earn, make more money, and lead a blissful life will never change.
Yeah.
And the Arishad Vargas, that is the 6 enemies within, is what we call, that will not change.
Mm.
These are all timeless aspects.
Mm.
So whenever you try to regulate these things by laws, those also can't change.
Right. True.
This is
Yeah.
precisely why some of these laws have remained timeless, I should say.
Mm.
And whenever you say, for example, you want to earn money and you want to deal with business, you would form partnership. You alone may not be able to do.
Yeah.
You need the help of
Someone
somebody
else.
in order to do it. So automatically you will have. And the man's idea of possessing a land, building a house, that will never change.
Yeah.
It can be from day one until now. And the expansion of the city, many people trying to come and stay in a particular place and expanding, the value being increasing.
Mm.
And as a result of which you would want more property, you may not have the resources, so you will go to devious and dubious methods, try to acquire something, injure somebody. Those are also very, very innate human qualities. So we see this from Ramayana, Mahabharata until today. So when the aspect of human element does not change, the laws regulating it obviously cannot change. So therefore I think there is this continuity in that particular laws. That's what I feel.
Cool. So because we are talking about the constants, the constant requirement of being humans.
Yeah.
In terms of laws, right? What are the differences or similarities that Dharmashastras had and current day constitution? What is that? Is there similarity? What is the difference? Can we go through that?
Yeah. So on the face of it, I can say that the earlier laws, as well as the what we call as the constitutional law, not constitution per se, because constitutional law includes constitution and administrative laws. So the constitutional laws and the Dharmashastras, if you look at it, the Dharmashastras were both prescriptive and they were also restrictive. In the sense, the Dharmashastras would tell you how you are supposed to lead life.
Okay, it's like a guideline.
The Dharmashastras also told the king how he is supposed to maintain his kingdom, how he is supposed to administer. It tells the judge how he is supposed to render a particular proper judicial decision. So there is innate for everybody on what are they supposed to take and as a guiding principle in life and continue. And it also puts a limitation on what you are not supposed to do. Don't injure others. Don't break the contract. If you have agreed to something, do it. These are the things. These are restrictive. These are restrictive in nature. So it's both prescriptive and restrictive. The present day laws never prescribes on how you are supposed to lead your life. It does not say how you are supposed to do business. It does not say how you are supposed to administer, how you are supposed to hold the government and run it effectively. If you read the constitution, it does not say how government is supposed to function. It only says there is the 3 organs. Legislature is supposed to make the laws. What law should it make? On what subject it should make? What should be the agenda of the government? There is no guideline on it. to some extent, the guidelines can be under the directive principles of state policy. It is again at a very materialistic level. On you have to ensure that everybody has work, has employment. You're supposed to give livelihood to everyone. These are some of the aspects that are covered under the directive principles of state policy. But in detail, to the extent of detail we see in the Dharmashastras, those prescriptions are not found in the present day law. See, as simple as you have the Marriage Act, Hindu Marriage Act. Hindu Marriage Act will not say how you are supposed to lead a happy married life. Correct? It only says what are the qualifications of a man and a woman to come together and marry, what are the conditions of a marriage, and if in case you break, what are the remedies available to you. So to that extent, the prescription element is gone away. And under the old, under the Dharmashastras, we see the 4 components, which are Achara, Vyavahara, Prayaschitta and Danda.
Okay.
So Achara is your conduct and what you are supposed to do. Then Vyavahara, I already told you on the transactions and things like that. The Prayaschitta is atonement. That is, it is not, Danda is an external agency where you have done a particular wrong, the government comes and punishes you. The police come and punish you. Or the courts levy a penalty on you. That is Danda. Prayaschitta is not any extrinsic, it is intrinsic, where you feel that you have done a particular wrong and therefore you are trying to do something in order to overcome it. So Prayaschitta requires your intrinsic examination, whereas Danda requires external evidence. Unless until there is an evidence, nothing can be proved against you. So there is a famous saying, no, when have you committed a crime? Not when you commit the crime. When you commit a crime and get caught is when you will be punished. So similarly, the Prayaschitta is a component which is there under the Dharmashastras. Now, the Achara and Prayaschitta are left out under the present day laws. The Vyavahara and Danda continues to remain even under the present day laws. These are in theory the major difference, I can say, between the older ones, the Dharmashastras and the present day laws.
I would say it's taking away the essence of it actually. Maybe
partial, I can say,
because it's only taken the transactional as well as the external force of law, that I am telling you to do this. I am giving you the punishment, but it is not even telling. It's not giving a guideline that okay, what am I supposed to do? Because I'm a designer, so when I design things on it's a software design, there is a thing called as error prevention. So you prevent the error, not allow the user to make the error and say, oh boss, you did an error. It's something similar. Is that correct?
Yeah, you're right. It's well put. I think that is what it makes. One other thing I would like to add here is that under the Dharmashastras can never be seen in isolation to the overall essential aspects of the Sanatana Dharma.
Yeah.
See, because Dharmashastra ultimately is part of Kalpasutras. Kalpasutra is part of Vedas. This thing. And Dharmashastras is nothing but a science for Dharma, which is one of the 4 components of realizing the Purusharthas. So, whatever you are doing under the Dharmashastras ultimately should lead to 2 things. One is individual advancement. Each particular individual should ensure that he leads his life in a dharmic way, in a proper way, and the utilization of the resources is also to such an extent that you don't harm the society in any particular way. It's not about what you are getting alone. It is to ensure that the least is harm to the society when you're getting what you are getting. And at the level of administration, the law is also that it says under the Dharmashastras that firstly the Raja is supposed to see the subjects as his own kids. He is supposed to ensure that governance is proper. These are the elements of showing as to what are the basic principles of governance. And under that they will say you do this, you don't do that. Now, if you don't prescribe anything and if you only stop and say that you're not supposed to do this, even now I think for everybody, when the way they are leading their particular life to make it more purposeful or anything, they again fall back on their uh, the aspects in Dharma Shastra. They may not know that.
Know it, yeah.
You may not be conscious of what you are doing, but you are falling back and seeing Dharma. As simple as in a proper, you go to buy something from a vegetable vendor or a fruit vendor also. You give less than what you would have said. You said, sir, what dharma are you doing if you don't pay me less?
Correct.
Without knowing the essence of it, people use it in, in an involuntary way. It has seeped deep into the minds of the public. So therefore, to that extent, there is a famous saying of Ambedkar after the constitution was written. He said, with this constitution, I cannot say that the country will always, advance further and it will always do well. You can have this constitution and make the best use of it and have the best government also. With the same constitution, you can also have the worst form of government and there can be anarchy also. So the constitution per se does not do anything. Using that constitution, what to do? It ultimately falls to the persons who are in charge of the government to see to it that by using what is framed into the constitution, how best can you rule?
So what I am probably understanding is, now you said only the Vyavahara and the Danda part of it was kind of included into the current constitution.
Correct.
Is this because of the colonial hangover that was there, or colonial invasion that happened, that there was a enforcement of this British kind of a law that was there, that, and also you also mentioned that personal laws were different, right? There was a Muslim personal law, there was a Hindu personal law over there. Now when you talk about the other two things, which is prescriptions, right? Prescriptions and
Achara and Prayaschitta.
Achara and Prayaschitta, they somehow get into the personal aspect of a person living, right? So then that will sort of get mixed with the religious practices of that person. Is that right?
You're right. You're absolutely right.
So that's why it was kept out?
You're precisely right.
Okay.
Of course.
So kind of it's like a secularization of the constitution. Is that correct?
Of course.
Okay.
In order to make the constitution secular, you could not have gone into the aspects on some of these guidelines, is what they feel. But that brings us to another question. Is Dharmashastra not secular?
Yeah, exactly. That's my point.
So, of course, the Dharmashastras were secular only because it was written in Sanskrit, and Indians and Hindus have been using it for a longer time. To say that it was not secular, it was religious is different. Because see, the very word religion and dharma, if you just look at the etymology of it, what is religion? Religion comes from a Latin word called legio or legio. Legio or legio means to bind, to connect. The medical terminology ligament also comes from this word called to bind or to connect. Now you have revise, review. The word re means back once again. So religio means you are coming back again, you are connecting again, you are binding the people again for that one single cause. Now what is the cause? It is for the purpose of your ritualistic practices or the god. You are coming back again to have your internal salvation with the god is the meaning. And in Middle English it became religion, and later in the English it became religion. So that's why you come back for prayers again, you come back for consecrations again. These are some of the ritualistic aspects which were binding together again people to come back to a particular place and to pray. This is the route through which the word religion comes into picture. Whereas dharma is not anything to do with your ritualistic or religious practices. Because the options to you is always available under the, even see, Dharmashastras hardly have any references saying that you are supposed to pray to this particular god or to that particular. Hinduism itself does not have. So obviously Dharmashastra also does not have. Under the Achara or in the Shodasha Samskaras, there are particular mantras which say that I am invoking Rudra, I am invoking Agni, I am invoking so and so, to that extent. Otherwise, it does not say that you are supposed to bow down to this particular god per se. It is left to the freedom. And see, even under the constitution, your article 25, which is there, which is one of the fundamental rights, gives you the freedom of conscience, which is one of the chief rights, which says that to your conscience, whatever you feel correct to for your spiritual salvation or for your leading your life or advancement in your career, whatever way, if according to your conscience, if you have to pray in a particular way or go to a particular faith, that particular freedom is there with you. Right to religion is there is a set religious practices which is already there. So you are saying I'll propagate that particular religion, I'll practice that particular religion. So it is again sectarian to that extent. But freedom of conscience is your Atma Sakshi. That is what you feel correct that you are trying to do. So that particular freedom is also given under the constitution. But again, it is subjective. Article 25, the very first line says that subject to other provisions of this part. This part means fundamental rights. So you have right to equality, life, the 7 freedoms, and so on and so forth. Subject to the other rights, I am giving you this particular right. And every right under the constitution, any fundamental right for that matter, is not, it's not indefinite, or it is not a blanket right that is being given to anyone. There is restrictions always being given. In what way? You say that you have the freedom of speech and expression, subject to reasonable restrictions being placed by the government in the interests of unity and integrity of India, security of the state, so on and so forth. So the rights are always under the constitution, the governmental rights versus the individual rights. Because what is security of India? What is integrity of India? What is unity of India? Who will say this? The government will say that by virtue of a law. So even your right to life, the Article 21 says no person shall be deprived of life or personal liberty except in accordance with law. So if a law can come and curtail your right to life or personal liberty, you cannot question it. If there is no law, then you have the unbridled usage of your particular right. So these restrictions which are being placed under the constitution is in the hands of the government. So ultimately, practically, it is the rights of the government versus rights of the individual. And some of these rights which are available in the constitution, under the precedents or by the judges, when it was decided in various cases, the terminologies have been extended. It is in this expansion of these terminologies or the rights that were already there is where you get various other components which perhaps were there, what we see in Dharmashastra also.
Okay.
For example, the state shall not deny to any person equality before the law or equal opportunity before the law. That is Article 14, which is the right to equality. Now, this 2 lines have been expanded in various decisions to say, if you do something arbitrarily under the administration, that arbitrariness is anathema to equality, therefore it is violative of Article 14. You don't find the word arbitrary or fairness or natural justice under Article 14. These were components which were added by the judgments subsequently. Because what happens, it is when the cases are being put up before the courts, you have the dynamics of a particular fact of the case. There are 1 or 2 people who are on dispute, or the state and a particular individual or a group of individuals are in dispute. That is when the law will have to be interpreted. Using that, the judges have interpreted it and the courts have interpreted it in a particular way, wherein they have said this is what the law is about. So the precedent made law, or the judge made law, or the court made law is more descriptive in nature, and in that we find a lot of similarity in the Dharmashastra and here, not between the statute per se and the Dharmashastra.
Okay. So one major difference that we just discussed was only the Vyavahara and the Danda was included in the current constitution. What else? Is there anything else that was omitted, or is there a difference?
Yeah, one other with respect to with respect to religion under the constitution, what we can say is you have mata, which is sect, which is more towards the ritualistic elements of your religion. Mata, dharma, and adhyatma are three completely different components.
Mm.
You don't see this differentiation in while speaking about the right to religion,
Mm.
so on and so forth. That while even translating the constitution from English to Hindi, so the Hindi Samvidhana translates religion to dharma.
Wow. The whole thing crumbles.
So the word dharma comes only in the Hindi translation, and that's for Article 25, and where it says wherever the word dharma comes in in the constitution in the Hindi, it's for translation for religion. Religion, of course, can also be one of the components of dharma, but that itself can't be, because see, dharma operates at three levels: adhibhuta, adhidaiva, adhyatma, all three levels. That is at materialistic level, at ritualistic level, and also at the spiritual level
Mm.
or the philosophical level. At all three levels, dharma operates. Whereas the moment you say religion, it does not operate at the philosophical level much. It is not a study of philosophy, it's more at the materialistic and ritualistic level only.
Mm.
So, those kind of differentiation that is available in the Dharma Shastra or any of the core aspects of Sanatana Dharma, that you don't find it differentiated in the laws.
Mm. So this renaming or translation has done more damage than anything,
Yeah,
I would
that's
say,
true. That's true.
because dharma as a concept, as a meaning itself, is very different or not at all anywhere close to religion.
Correct, correct.
Because and then that Hindi translation, I think that one has to be changed immediately. Right. Okay. Is there anything else as a different thing that was there?
Mostly, I mean, if you get to the details, you can see a lot of differences.
Hmm.
But not getting into the details uh, at the very philosophy of how the Dharmashastras were being framed or looked into, as against how the laws or even the constitution was being framed into. I think these are the cardinal differences.
Hmm.
If you look at the applications, I can go on and on at various things.
Yeah, because you already said Dharmashastras were based on materialistic, philosophical, and also the spiritual,
Or yeah,
philosophical. I mean, yeah, spiritual
materialistic, ritualistic, and philosophical. All
philosophy,
three.
right?
Yeah,
But whereas the constitution today is only based on materialistic.
materialistic, and it does not deal again on ritualistic aspects also, or not, and but it gives you the freedom to take whatever ritual or philosophy that it wants. To that extent, it stops. It doesn't go further.
Yeah, basically, again, this is my observation from whatever talks. It is the complete sattva or the essence of that Dharma Shastra goes away because of that. Don't you think so?
Yes. So, but again, if you look at it, can we bring it back into the any of our laws or constitution? The answer is no.
No.
We can't, because when the Dharmashastras were written, we did not have different religions all falling into one place, and Dharmashastras are also silent about what you are supposed to do when there is onslaught, or when there is religious intolerance between two religion. What are we supposed to do on
They
all?
didn't envision it.
They probably did not envision it, or even if they did, nothing has been written.
Okay.
So
these are some of the lackings.
yeah, but the problem is the evidence. The absence of evidence is not evidence of absence. So we cannot say what was not written was never written, but at least to the extent of texts available today and to the extent of what I have read, my knowledge is also limited. I don't see this anywhere on those aspects. But under the present day scenario, to say the Dharmashastra's element should be completely put back may be incorrect. But certainly one should read. The education on Dharmashastras, I think, has become even more relevant today, because you know what existed, what was there, and laws need not have to change. The laws can remain as it is, but the manner in which we are approaching those particular laws will certainly change, and the perspective will change. So therefore, the Dharmashastras, or even the core aspects of Sanatana Dharma, I think, should be understood in spirit and practiced in spirit, not in letter. The laws need not have to change today to say the right to Purushartha is a fundamental right. I'm not saying that needs to be done. But the approach and perspective will change. Because you have seen some of the judgments being passed wherein some of the beliefs have been questioned, some of the rituals in a particular temple being questioned. If you understand why that particular ritual was there, or why that particular as to who can attend a temple, who need not have to attend a temple, why did it even come into picture, and what are the rights available, is the religion itself so intolerant or not? These are things which will be clean as extremely clean to you the moment you start reading some of these, to say that you don't find all those intolerant attitude in any of the Dharmashastras at all. So the moment you understand that, your perspective towards looking at that particular religion will automatically change.
So anybody reading about or want to read about Dharmashastras, right? Or today's people practicing law, they don't come reading Dharmashastras for sure.
100%.
Right.
They see legal studies now, when we are taught the Hindu law, we read a small paragraph saying that the Hindu laws, that is the law of succession, etc., there are two. One is codified law, one is uncodified law. So before 1956 was uncodified Hindu law. And they say for uncodified Hindu law, they had to base it on Dharmashastras. So the reading of Dharmashastras for law students is limited to property succession, partition, that is Daya Bhaga, and your marriage, subject on marriage, and then adoption and maintenance, and woman's right of maintenance, or so on and so forth, under her marital issues, if any. Those are the limited sphere to which we say Dharmashastra should be looked into as part of legal studies.
That's about it.
That's about it. Apart from that, it does not even mention as to what all is covered under Dharmashastra, and then persons reading it are also, of course, very, very minimal,
Very
I should
few.
say. Yeah.
Do you think it is necessary?
Of course, it is necessary, not with a view to say that you change the legal subjects or the way in which our courts are practicing, but your perspective of looking at things will definitely improve if you read Dharmashastra. At least to me, after I read Dharmashastra, I was able to notice what are the timeless, laws and the manner in which society exists at all times. What are the laws which will possibly never change except for minor alterations here and there on procedure. So you have form and content. Similarly, in law, we have procedural law and substantial law. So the procedural law will always change from time to time. The procedure that stood some 50, 60 years back is now changed. So similarly, it will continue to change. The procedures will change. But the substantive laws will more or less continue to rule in the same way with minor alterations. So these, when you look at Dharmashastras and you look at the discussion on that particular subject, you won't find too much of a difference. For example, let me quote a padya of Kautilya in the Arthashastra. While speaking about how the courts are supposed to render judgments, he says, Dharmascha Vyavaharascha Charitram Rajashasanam Vivadarthas Chatushpadaha Paschimah Purvabhadakaha. He says, Dharma, that is your Dharmashastra, or what the actual Dharma is, which we can possibly today in a vague way translate it to your statute and law digest. Then Vyavaharascha, that is your that particular contract or evidence in that particular matter. Charitram is history or precedents. More than history, you can probably translate it as precedents, old cases, the manner in which the judgments were rendered. Rajashasanam, that is government order or royal edict. These are the 4 legs for rendering justice. Vivadarthas chatushpadaha, in order to render justice while in any particular case, these 4 will come to your rescue. Paschima purvabadakaha, the latter one will supersede over the former. That is, first you will see a government order. What is the government order? That will rule over what was the precedent. Precedent can be something, but for present day, if there is a government order, you will go by that particular government order. For example, you had COVID. When COVID happened, your law is you have your freedom of right to move freely throughout the territory of India. It's a fundamental right. That is taken away that for that particular period in order to achieve something else. So that will become even more relevant to you at that point of time. That is more important than the precedent. Precedent is more important than what can be there in the contract between the two of you, because how the contract is interpreted is always there in the precedent. Then what is there in the contract is more important than what the statute may say, because many of the statute says unless the contract is there to the contrary, this is what the rule is. So contract will rule over the statute. So these are the manner in which it has to be rendered. Even to this day, we are practicing the same thing. Just that we may not look at Arthashastra, but we look at this.
This is already known.
It's already known, but yeah, we reinvent things once again. This is what it is.
It's like in a new package, you give it and you say the same thing, like last episode that we concluded, that if it comes from somewhere else, especially from the West, that this is what we are giving you, we take it and then, oh yeah, this is a good thing to adopt. That's what we do.
Correct.
Because it's like we have become brown sahibs, is what I...
Also white man's burden for them to...
to give us.
Us, yeah.
So let's say, what's the ideal world for you in terms of the constitution? Is there an ideal world where this can be combined with the Dharmashastras and the current way of living? What can be done? Because today, if you see, a lot of individualism is growing, right? The rights, people asking rights have grown, right? In terms of the wokeism and all these things that are coming, right? Today I am this, today I am that. You have to respect my right, and so many things are happening. Everybody is asking for their rights, even in terms of in our own country, the caste system. Each caste is asking that we need rights for us, right? So how do you balance all of this in terms of that?
See, to answer that in the backdrop of constitution is that our constitution gives fundamental rights to everyone which are justiciable. Means that if a fundamental right given to you is taken away, you can go to the court and get a decree against the government or a writ issued against the government saying that this is his fundamental right, don't stop it, and it will be given to you. Even some of the laws, if it in case it is made which is against your fundamental right, that laws have also been struck down as unconstitutional because it violates part 3, that is fundamental rights of the constitution. The fundamental duties was never there in the constitution. The article 51A which was put was a subsequent insertion. There are some fundamental duties which they say, but what happens if you don't follow the fundamental duties? You don't do anything. So it has remained more or less as a dead letter in the constitution, the fundamental duties. And of course, the fundamental duties are also not exhaustive. And it does not, according to me, carry the same spirit as what could be found in Dharmashastras. In the Dharmashastras, it was more a duty-conscious society.
Yeah.
What we are presently living in is more on a right-conscious society.
Yeah.
It is a problem of the society in general. It is not the constitution's problem, I should say. It is the society's problem. You are at the individual level. What is liberty to me? And what is the freedom that is given to me? What are my rights? And it is always at a individual level. The earlier laws, or even the manner of regulation of society in the earlier days. So if you look at the Western way, it is top-down approach. They say first the society will have to be rectified, If the society is running fine, then the community should be fine. If the community is fine, then the individual should be fine. In the Indian way or the Eastern way, it is the reverse. All the scriptures that are there, none need not be Dharma Shastra, everything else is trying to make that particular individual proper and perfect. So the concept is, if an individual is fine and if he is in the right frame, automatically he'll keep his family in the right frame. And if the family is fine, it will automatically keep the community in the right frame and society also in the right frame. So we have a bottom to top approach and the West has a top to bottom approach. So there it is about conferment of rights. That these are the rights that is being conferred to you and what it exists. And if it is not being given to you, you can approach the court, you can take and you can fight for your rights. But what about the duty of every particular individual that is there? The laws are always silent on that. So a duty conscious society is what is meant. The takeaway from the Dharmashastras can be that the spirit of the Dharmashastra should live in us. To say that the constitution will have to be amended or change the law courses to say that all Dharmashastra should be taught and not the subjects. Now lawyers will read more of Dharmashastra and go to courts rather than seeing this. While arguing, you only quote Dharmashastras and not precedents or the present law. These are all rubbish, but unfortunately it is happening. In spirit it should remain. In spirit it should continue to live. But in letter, you cannot change what it is today and say we will change the entire system, because in the present day, I think we will make fool out of ourselves if we try to do that. That's my personal
Totally impractical.
But in spirit, it should continue to remain.
This is something which is hitting our judicial system, which is there, right? It's the number of cases and the number of judges that are there, right? It's always disproportionate. The number of cases are like, I can say, years together, not even the number, it's years. I don't know what's an ideal world for that. Is like appoint so many judges and it will get resolved, or like how will, if I go to the court today, I don't want to go to the court today. I can tell you one personal case which is going on right now, but that is offline. But for me to approach a court today, it's like I don't want to. It's that way, because it takes time, and it's better I invest my time somewhere else is the point that I have, at least. So how do you have an ideal situation or an ideal world that this should happen? Is there a
See, this, of course, for this question, I should say more number of courts have only meant more number of litigations. Earlier also and now also, and we have seen through the years, maybe 30 years down before, the number of courts that we had, number of tribunals that we had were a lot lesser compared to how it is today. And more number of judges, yes, certainly that is required, but we also have more number of judges. The problem that requires to be resolved, according to me, is in the appointment of judges. The appointment of judges, it is not the number that is necessary, it is the efficiency that is necessary.
The system that appoints the judges, you mean?
One, that, and number two, what are you looking in the qualification for a judge? What are you seeing, and what are the kind of persons that you are appointing? So it's all about efficiency. And it's not only for judiciary, I think it's even for the government, for that matter. Whom you appoint, the type of people that you appoint is important. The food for thought would be, what is in there for meritorious people to even be appointed in any governmental position. One, their merit should be recognized, and number two, they need to be compensated well. And meritocracy should always be rewarded. If this is taken care, I think it is an answer for various issues pertaining to red tapeism or bureaucratical issues that are there, including judiciary. if you don't address this particular issue, and you can be a meritorious person, but still you will be subjected to ABC, and you will still have to bow down to somebody who's not so meritorious. At the same time, there is no special thing being recognized or being given to you only because you are more meritorious than somebody else. You will still fall in line, and the promotion will come in due place for you only. And somebody sitting over you can always do something to you in your career, either encourage it or even finish it.
Finish
That kind of attitude, if it is there, it doesn't entice somebody to be in the bureaucratical setup of the government and run. So the more and more your people keeping meritocratic people outside of the government, these issues will continue to persist. So number of judges, including the present government, is boasting that we have almost filled 90% of all vacancy that was there in the High Court, and they in turn will take care of the vacancies of the lower courts. All that is fine. But what kind of judges are you appointing?
Yeah.
How much is their expertise in what kind of law? So this qualitative correction is more needed in the government as also in the judiciary. And this qualitative correction can only happen from top. It cannot happen from down. It has to happen from top. And when that happens, that can only be the answer, which I don't see happening anytime soon.
So the government has to follow its Swadharma.
Government also is not, it does not have its free hand in appointment of judges either. Okay, India is a system where judges appoint judges. So the Supreme Court Collegium will have to recommend, and the government will have to accept or reject that particular selection. The government cannot go back and say, I want so-and-so to be the judge, kindly move his name. That also it has to be unofficial, nothing official. So that is a problem.
So each one has to follow their Swadharma.
Of course. The Swadharma is the basic root.
Correct. Finally, that is what we'll end with.
Correct.
If everybody follows their Swadharma,
correct,
everything will be
correct. Absolutely. Absolutely.
Thank you so much.
Thank you.
And thank you for sharing your wisdom and knowledge.
Thank you. Thank you very much again for inviting me here and talking to me on this subject. There are not many who even, go deeper in this particular subject. And I only hope that this podcast makes people read the pages of P.V. Kane's Dharma Shastra or something else, and they get more involved in it. Yeah. Thank you very much.
Thank you.